Hello, this is attorney Andrew from the law firm Gilliland Law. Our slogan is protecting what's yours. And one thing that you might want to consider protecting is your pet. So I just want to talk a little bit about how to create a pet trust and how that fits into a typical estate plan. So if you look up at the top here on the left-hand side, you can see your estate plan. And then you have the arrows coming in the yellow box, it says a survivor's trust. That typically is the trust of, if you have a significant other or are married, that would be the trust of your survivor. The children's trust, as the name implies, goes to the children. You can also put in a grandchildren's trust. That's the beauty of a living trust, is that it is entirely flexible as to how we want to set it up, who we want to be the beneficiaries of the trust. Remember, a trust requires an intent, and that's why you do a writing. It also requires a grantor, and that would be you. It then requires a beneficiary. In this case, we have the survivor of the two of you and your spouse or significant other. A children could be a beneficiary, a grandchildren, and we're going to talk a minute about how a pet can also be a beneficiary. So you have to have, again, an intent, you have a grantor, you have a beneficiary, and then you have to have property to put into the trust. And then finally, you have to have a trustee, somebody who is going to run the trust in accordance with your desires. And that's why, again, going back to the first one, the intent, putting it into writing. So once again, we have your estate plan. And a pet trust does seamlessly meshes into your existing or a new estate plan. It wouldn't interfere with the survivor's trust, wouldn't interfere with the children's trust or a grandchildren's trust. So a pet trust would be a fourth type of trust that could be created within one trust instrument. Now the beauty of it, you can say, well, whoa, why do I want to make this so complex? Well, the reality is that what happens is, let's say you and your spouse create a trust, and then you have the survivor's trust. For the most part, that survivor's trust, all the assets go into that survivor's trust. The income is doled out to the survivor, and then whether or not they can get at the principal, like the resident, or sell the shares of stocks, or go get into the 401k, whatever it is, that can be determined based on the nature of that relationship. So, for example, if you had a long-term relationship with a single individual and all your children are common, you may not care because you're going to assume that the survivor of you or your spouse will act on their best behalf, in their best interest. However, if you have a blended family, which is more the norm, you're going to maybe want to put some limits on what the survivor can do, again, depending on the length of the relationship, the marriage, the relationship between your second or third spouse and the children. So, there are things that you can do with it. However, one thing that you can do in all situations is to create a pet trust within your current estate plan. So if you look under the blue box there where it says pet trust, the first thing you need to do is name a character, a caretaker, the guardian for the pet. Okay, this could be, again, your surviving spouse. It could be a child. It could be a grandchild. It could also be a third party. It could be anyone that you believe will act in your pet's best interest. Then also in the trust, you want to leave instructions for the care of your pet. You want to specify what how you want your pet to be taken care of, the level of veterinary care, the types of meals. You can really put anything in there, or it could just be blanket that you just want somebody to make sure they take care of your dog or your cat or your horse or whatever it may be. You need to specify an amount of money to be used for the benefit of your pet, along with naming a trustee to manage the money. So what you could say is 5% of my estate, or you can say up to $10,000, whatever that amount is based on your situation and the care of your pet and the desire you have to do this. And again, what instructions you want for your trustee to take care of the pet. And again, that could be the caretaker and the trustee do not have to be the same individual, or they could be the same individual. Finally, you want to select the remainder beneficiary, if any of the funds remain after your pet's death. So if your pet were to pass away a year and only had gone through, we'll just say, through $10,000, only had gone through $1,000 or $2,000 based on the, what we believe would be the longevity, and that's kind of how we would set up the amount. So if that pet dies before all the funds are spent on the pet, then really we have to determine what would happen to it. And typically that's just going to go roll back into either the survivor's trust, the children's trust, or the grandchildren's trust, or maybe all three. All right. So how does a pet trust work at your death or incapacity? Because again, this applies to incapacity. You don't necessarily have to be passed. You could also not be able to take care of your pet. Okay. So for your pet goes to the caretaker whom you selected. The caretaker cares for your pet based on the instructions in your trust. So again, you can dictate, or again, you could just leave it, broad in general. You could be very specific as to what you want your caretaker to do. All right, so that's your pet. Now, what about your money? The money you set aside is managed by the trustee you selected. Okay, again, the trustee and the caretaker don't have to be the same individual, although they could. The trustee then would give the money to your pet's caretaker for your pet's care based on the guidelines you provide in the trust. That's the simple nature of how it works when you can no longer do it. It's that trustee. And again, it could be your surviving spouse, could be a children, a grandchild, and the caretaker could entirely be different. So for example, if it was you and your spouse and you have both had health issues and could not take care of the pet as much as you would want to, maybe you're a little bit better physically to take care of the pet. What would happen if you become incapacitated? What would your spouse do then? That's why the caretaker can be slightly different. So after your pet passes away, right, your pet's caretaker will handle your pet's final arrangements. And that money could come out of the trust, okay? And you could put that in there and say, hey, the income that would have gone to the pet can be used for the pet's final arrangements. Any money that's left over is distributed by the trustee you selected to whomever you want to go, to the remainder of beneficiaries you selected in your pet trust, like a pet charity. But again, it doesn't have to go to your survivor, the children or grandchildren. You can do a pet charity, or the caretaker can get the money. A surviving spouse, anyone can really get it. It's just a matter of dictating what you would like to happen. So a pet trust entirely fits within any estate plan. Even the most simple living trust can have a pet trust within it, as long as we can satisfy naming of a caretaker, leaving instructions, again, very specific or just general, and specifying an amount of money and then what's going to happen to that amount of money should your pet pass before that amount of money is spent. If you have any further questions, again, this is just general advice. This is not intended to be legal advice. You would want to talk to an attorney such as myself to determine what the specific aspects of your pet trust. But you have my phone number down there, 760-237-0323. There's also, I have an office in Carlsbad. I do have an office in Riverside as well. Or you could just visit my website at www.gillalandlaw.com. Thank you. And again, remember that this is an important aspect to figure out how to take care of your pet should you have a pet within your remaining estate.